Good afternoon, everyone. Thank you so much for being here. I would like to welcome you to our webinar on legal support for survivors of intimate partner violence, common client issues, which is hosted by METRAC. My name is Andrea Collins Fitzpatrick, and I'm the legal director for METRAC's Community Justice Program. I would like to begin today with a land acknowledgement. We acknowledge that this land is the traditional territory of many nations, including the Huron-Wendat, Haudenosaunee, and the Mississaugas of the Credit. Today, the meeting place of Toronto is still home to many Indigenous people. We honor all the First Nation, Métis, and Inuit people living on this land. We recognize the traditional territories on which our organization is located and on which our programs and trainings take place. I would like to remind you that this webinar is for general information purposes only and is not legal advice. The legal information provided is not intended to be used as legal advice for a specific legal problem. I would also like to let you know that this webinar will be recorded and will be posted on our website at onefamilylaw.ca. That's onefamilylaw.ca. I would also like to remind you that we will have a Q&A after the presentation. If you have any questions, please post them in the chat. We also have a survey that we would please like you to fill out, and it will be posted in the chat towards the end of the presentation. Before I move to our presenters today, I would like to tell you a bit about METRAC. METRAC works to end gender-based violence across communities through education, research, and policies. We have been in existence since 1984, so 40 years this year, and our programs are devoted to advancing safety, justice, and equity. METRAC's Community Justice Program provides legal education and information related to gender-based violence. Through our Access to Justice program, we provide legal information in areas of family law, immigration law, criminal law, employment law, and human rights law. This webinar is part of our Family Law Education for Women, FLU series. FLU's resources are available in 14 languages, ASL videos, and accessible formats. You can visit our website at onefamilylaw.ca, so onefamilylaw.ca, for more information on your family law matters. I'm delighted to welcome Emma Katz and Kate Deveau to speak to us about legal support for survivors of intimate partner violence, common client issues. Emma is a family lawyer at Kelly D. Jordan Family Law Firm and was called to the bar in 2013. After practicing civil litigation in the earlier part of her career, she transitioned to family law so she could advocate for individuals. She practices in all areas of family law, including parenting, as well as complex financial issues, and also practices fertility law, drafting and providing legal advice regarding donor and surrogacy agreements, and litigating issues that arise. Emma is a seasoned litigator who's been arguing in courts and in front of tribunals since she was an articling student. She also understands the importance of negotiating resolutions through alternative dispute resolution when appropriate. Emma has completed the fundamentals and advanced mediation training with the Mediation Training Center. She is a member of the Ontario Bar Association Family Law Executive and past member of the Ontario Bar Association Young Lawyers Division Executive. Emma contributed to writing resources regarding decision-making responsibility and parenting time for Family Law Education for Women, FLU, and a family chapter in the new edition of A Taxpayer. Emma grew up in Toronto and is strongly connected to her community. She completed her Juris Doctor at Osgoode Hall Law School, during which time she spent one semester working at Parkdale Community Legal Services. Emma is a member of the Board of Directors for the Justice for Children and Youth Legal Clinic and is also a member of their Development and Fundraising Committee. I'd also like to introduce Kate Deveau. Kate, who is co-presenting with Emma today, is an associate lawyer with Kelly D. Jordan Family Law Firm and practices all areas of family law. She's also a member of the Personal Rights Panel of the Office of the Children's Lawyer. She is also a member of Ontario Bar Association Child and Youth Executive Committee and has a particular interest advocating for the rights of the child. Thank you so much, Emma and Kate. We're delighted to have you here today. And now pass things over to Emma.
Thanks very much, Andrea and Kenny Ann, for putting this together. We are definitely big supporters of METRAC and the legal education provided. And I just wanted to start by saying we're going to talk today about some resources. We don't specifically mention METRAC, but just know that we obviously absolutely direct you to all of the amazing information that you can receive at the One Family Law website. And just thank you very much for putting on these types of programs. So we're going to talk today about representing clients who are survivors or continue to experience intimate partner violence. What I can tell you is that we are seeing, from an anecdotal perspective, a huge rise in the number of clients that we're working with where there is an element of intimate partner violence. We're also seeing a big rise in cases involving addiction, mental health issues. I can't speak to the statistics of that at all, obviously, but I can just tell you that from pre-pandemic to post-pandemic, there is a very notable difference in the volume of cases that are including those issues. And I don't know whether it's because they are increasing or because there's more reporting or because the courts have started to care more about it. That is really not something that I'm going to weigh in on or guess, but I can just tell you that it's certainly very prevalent and is taking up a lot of space in the courts. So just to kind of go back to the beginning, I guess, or where it all, the first principles for us, which is legislation. So the Canadian legal system has definitely made some steps in the what we would call the right direction to better understand intimate partner violence and recognize the harm and effects it has on women and children. That being said, there's been a lot of problems with the way in which the family law system, for example, has operated on myths and assumptions regarding intimate partner violence that marginalize women and children due to judicial perceptions, and also just the way that that impacts women actually wanting to take part in the system at all. In the past, what I would call hindrances to the courts taking intimate partner violence seriously were the following factors. So courts focusing on the future, not the past. Courts focusing on what we call the maximum contact principle, which was the idea that children should spend basically as much time as possible with both parents. Misconceptions that physical separation will end violence. Credibility issues, so concerns or findings that both parties engaged in violence, or that they're, on a he said, she said, they felt like they couldn't determine that it actually happened. And so all of this has resulted in victims not wanting to be in the court system for fear of interactions with the abuser. So fear of interactions, fear that they won't be properly heard or that they won't be protected, or a lot of times fear that they will lose their children because of threats made by the abuser, that they'll take their kids away, for example. And also a lot of times fears of leaving, knowing that there's this maximum contact principle that the courts really want to take seriously or prioritize, and therefore worrying that they can't actually be there to protect their kids. So I've often heard clients say things like, well, at least if I'm in the house, I know how to protect them. This slide here is showing what we did have recent changes to both the Divorce Act, which is the legislation that governs in Ontario but related to marriage, and the Children's Law Reform Act, which is specific Ontario legislation relating to parenting issues where the parties are not married, legally married. And so we have changes to both acts to now include a direct reference to family violence. And these changes came into force in March of 2021. So now we have a definition of family violence, which, as outlined in the slide, means any conduct, whether or not the conduct constitutes a criminal offense by a family member towards another family member, that is violent or threatening, or that constitutes a pattern of coercive and controlling behavior, or that causes that other family member to fear for their own safety or for that of another person. And in the case of a child, the direct or indirect exposure to such contact, and includes physical abuse, including forced confinement, but excluding the use of reasonable force to protect themselves or another person, sexual abuse, threats to kill or cause bodily harm to any person, harassment, including stalking, the failure to provide the necessity of life, psychological abuse, and financial abuse, threats to kill or harm an animal or damage property, and the killing or harming of an animal or the damaging of property. So it took a lot of work, a lot of really important outreach and lobbying for this to happen. And it definitely marks a significant change because we have an actual definition and it includes much more than physical violence, which was the other kind of issue that we faced before, which was that if there was no evidence of physical violence, often it wasn't taken seriously. All right, so how does the new definition of family violence actually apply to family law? So it comes into play for considering parenting issues, parenting orders, restraining orders, orders for exclusive possession, which is where one party is seeking a court order that they be allowed to remain in the matrimonial home exclusively without the other person having any ability to go there. It can come into play for child and spousal support and also preservation orders. So I'll talk a little bit more about that later, but that's the way in which that definition is used. Okay, so when it comes to parenting orders, it's used to determine as one of the factors what's in the child's best interest. Okay, so at this point, I'm going to turn it over to Kate, who's going to talk to us about risk assessment and initially how we determine whether or not there is intimate partner violence or coercive and controlling behavior at the initial stage when we meet with clients. And she's going to go through a risk assessment tool with you. But basically, what we want to kind of talk to you today about is sort of the role that we play from beginning to end. So oftentimes that starts with the initial consultation. It may very well just be an initial consultation. So it's really important that we make sure that we are seeing the signs, okay, identifying intimate partner violence and the risk for it, and providing information. And it may be that the person at this point, that's all that they can handle is that information. And it may be that we never see them again. It may be that we see them again 6 months later because something's changed or they've, changed their mind. But that initial consultation is critical, even if it's not a matter that ends up being an ongoing family matter, for example. It allows us to provide the person with education, referrals, safety information, and legal education as to what legal advice as to what they may or may not be able to do. So we'll start with that initial stage.
Thanks, Emma. Hello, everyone. As Emma mentioned, we're seeing a lot of IPV in our practice. And so it's really important that, we're all educated on how to deal with it when these issues arise. There are a lot of great resources out there, but I'm going to speak about 2 specific ones today. The first one is on the screen before you. It's a Department of Justice resource called the Help Toolkit. And I'm referring to this resource mainly for a general approach to how we deal with these issues. And then I am also going to speak to the Barbara Schleifer Commemorative Clinic Toolkit. And it's a risk identification and assessment tool. So that gives you some really specific questions to ask when these issues come up. So starting with the DOJ Help Toolkit, this is a toolkit that was developed with input from family law and family violence experts from across the country. And really, it's designed to respond to research calling for a tool designed specifically for family law legal advisors to use in identifying and responding to family violence. And it's also meant to be just a practical guide for legal advisors to gather information they need, both for the family law case and also to connect clients to other services to promote their safety. And, we generally recommend that this be incorporated into the legal advisor's existing practice. So when clients come to us, for instance, for an initial consult, some firms have checklists of going over the law with the client. Now we're seeing more and more that these risk identification and assessment tools are being incorporated into the initial consult checklist to make sure that we're getting the information that we need. When clients come to us, they may or may not disclose the family violence that they have or are experiencing. And there are several reasons for this. Clients may not voluntarily disclose because of just general discomfort about sharing, because they're concerned that we won't be interested or that we won't believe them. It may be that there's a lack of understanding that they are experiencing family violence or that it's relevant to their case, and then general fear for their safety and their family's safety. So it's really important as legal advisors to talk to clients about family violence on a regular basis. Client trauma can also affect the course of a family law case. So clients who've experienced trauma from family violence or other causes may not react in the ways that you might expect. So for instance, A victim of violence may struggle to focus on or convey particulars of traumatic events. They may have difficulty concentrating on what you're saying or be unable to provide meaningful instructions. So this toolkit really uses a trauma and violence-informed approach to help you work safely and effectively. So the approach is 4 parts right in front of you. So the first step is have an initial discussion about family violence. The second is explore immediate risks and safety concerns. The third is learn more about the family violence to help you determine what to recommend to your client. And then the last is to promote safety through the family law case. So I'll just touch on each to give you a sense of what we're looking for at each stage. Have an initial discussion about family violence. This is really about initiating a conversation, and it can happen in all sorts of different ways. So it may be that a client comes to you specifically about a family law issue that does relate to family violence, or it could be that they don't mention it, and throughout the course of your conversation with them, you become aware of possible family violence indicators. And then, if neither of those things, we recommend that you do introduce the topic of family violence by explaining what it is, because not all clients know what it is, and then asking if the client has experienced it. Regardless of how it's initiated, it's really important to follow the client's lead and to tailor your approach to the individual client's particular situation. Initial meetings with clients may not allow for sufficient time for an in-depth discussion of family violence, and your client might not be ready to disclose. So there's a piece around really developing trust with your client. But as Emma said, sometimes we're seeing clients just once, and so it is important to do your best on that first shot, and so that you can get them the information that they need and make sure that they're ultimately safe moving forward. So at this stage, just a couple, things you should be aware of. You are aware the client may suffer from trauma, which can affect how they interact with you. You should really try to understand how overlapping identities and experiences can shape this client's perspective. Really important to pay attention to potential indicators, and then introducing the topic of family violence if the client doesn't bring it up, as I said. Really try to normalize this conversation, saying things like, I ask all my clients about their experiences with family violence can sometimes help set the stage for that conversation. Then, listening without judgment, thanking the client for sharing, offering support, and then continuing to apply this model as we move forward into the next stage, which is explore. So this is it's important to note that when a client makes contact with a family law legal advisor, this can increase their risk of violence or of escalating violence. So sometimes we always ask, do you have privacy? But sometimes we're getting calls from people who are sitting in their cars. Sometimes clients are asking us if they can defer payment of their retainer, like if there are issues around, financial control, their ex manages their finances and would see if they were meeting with a lawyer. So it's really important to just understand that it is a really significant point in this person's life. At this stage, should be asking about, potential risk and safety concerns. And as I said, I'm going to go through a risk identification and assessment tool that can help with that. And then also asking about, dangerous safety plans, which Emma's going to discuss in a bit as well. Learning more about the family violence to help you determine what to recommend to your client. So this is gathering details about your client's experience of family violence, which will help you determine what types of family law processes and remedies are available to keep the client safe and that would be appropriate in their case. And it's likely that in most cases, hopefully the person is coming back to you for a second time, because it can be that you have to gather this information over the course of several meetings. And that could be for a few reasons like time constraints, or it can be just the client's level of comfort in disclosing and their ability to get into more details. But really important to continue to revisit the issue of family violence throughout the case. At this stage, you're asking about, different forms of family violence. You're asking about, while we have these checklists, you do want to try your best to incorporate it as naturally as possible into the conversation so as not to disrupt the flow of the discussion. You really want to try to understand the seriousness and the frequency and the duration of the violence that they're experiencing, and keeping a close lookout for coercive and controlling behaviors. And then, like I said, revisiting the issues. And then lastly is the promoting safety. So that's, family violence can be really unpredictable, and the risks might continue or increase or just change throughout the course of a family law case. So it's important to be checking in with clients about their immediate risks and safeties and watching for signs. Like, for instance, if there's a client who usually responds, pretty rapidly to your emails, but then isn't, you may want to check in. And at this promoting safety stage, you really want to be remembering that separation is a time of heightened risk for family violence, and developing safety plans as you go. So the next slide, I'm just going to speak about a couple tips for safe and effective discussions with clients. Again, this comes from the DOJ Help Toolkit, which I have found to be really helpful in my practice. Your ability to explore issues of family violence with your client in any given meeting is impacted by the complexity of the family law file and the realities of cost and time and your client's readiness to engage. But the help approach is really meant to be flexible. And so it's important to remember that what you learn about your client's experiences of family violence has the potential to impact many aspects of the family law case. Tips for safe and effective discussions. So understanding the impacts of the trauma. So trauma is both the experience of and a response to an overwhelming negative experience or event. And clients who have experienced trauma from family violence or other events may not react or interact in the ways that you expect. Understanding the effect of people's overlapping identities. So your clients will have multiple and diverse demographic characteristics that intersect to shape their perspectives and their ideologies and their experiences. These do not exist in isolation from one another. So they can compound a victim's experience of family violence and their sensitivity to perceived judgments and assumptions about their credibility. It's also really important here to be aware of your own biases and assumptions. You also want to understand the gendered nature of family violence. All members of a family can be victims of family violence, but there are gender differences. So for example, women do account for the vast majority of victims of police-reported intimate partner violence, including homicide. So additionally, Indigenous women and women with disabilities are more at risk of IPV than others. You also don't want to assume that a client has only experienced or only committed family violence. Like I said, family violence can be perpetrated by one person or more than one person in a family. And then you want to know that you might not get an answer. Some clients don't want to discuss this topic. It's very personal, it's very sensitive. So really respecting the client's autonomy. Then also just ensuring that you have sufficient time to have these discussions. These conversations can be incredibly distressing for clients and really shouldn't be rushed. Taking breaks is often one way to do that. The Department of Justice toolkit gives a really helpful overview, I think, of the things that we need to be aware of. You should read it. It's a longer report. It's like 124 pages, but it actually is really worth reading page to page. It does go through and ask specific questions that would be considered like a risk identification and assessment tool. But the one I'm going to discuss for that purpose is the Barbara Schleifer one. So if we just go to the next slide, I can explain how this one works. So this was back in 2020. The clinic received funding from the Law Foundation of Ontario, and it was a 2-year project, and it's called Enhanced Safety Risk Assessment Tool in Family Courts. And the project's main goal was to create a risk assessment tool to be used by family court stakeholders with survivors of intimate partner violence that are in contact with the family court. So the report, also over 100 pages, but well worth the read, shares the project's findings and the process for designing the IPV risk identification and assessment tool, and made it available for use by service providers. Service providers can use the resulting tool as a guide in identifying potential DV high-risk situations, but also, identifying proper steps to remedy these as effectively as possible. So research studies and death review committees have well acknowledged in cases where there's a risk for potential harm or lethality, it increases during or after separation. In fact, there's a statistic around 2/3 of domestic homicides occur during or pending separation. So most risk assessments are, overwhelmingly focused on the perpetrator's behavior and the potential risks for reoffense, with a primary emphasis on risk factors associated with physical violence. But this tool, part of what I like about it is that it asks questions that I think go deeper and that assess more than just physical violence, things like coercive and controlling behavior, which is something that we see a lot in family law. Another important thing about this assessment is that it did use an intersectional analysis. So it included questions seeking to, understand information on the additional risks that women face due to their social identity and also systemic oppressions. And these overlapping systems of oppression can definitely magnify risk factors for gender-based violence, including barriers to receiving services and finding safety. So really important to note that the assessment of risk does rely heavily on professional judgment. So where professional training and expertise and experience play a role while interviewing a survivor, it's really crucial to get training on these things. Great that these programs are being offered. Also really important as a practitioner to be aware of things like the survivor's body language, reactions to questions, being mindful of the trauma when conducting these interviews and asking questions. And then the other thing is the risk assessment must be ongoing, since, as I said, it can sort of change throughout the life of a family law file. So the IPV, I'm going to call it RIA, Risk Identification and Assessment. It has 3 parts, so it's a 3-part tool. And it was, designed after extensive consultation with the family court stakeholders and also survivors of violence. So I'm just going to go through the 3 parts. We could just go to the next slide. So our RIA1 is the screening. So it consists of 13 yes or no questions based on risk factors validated by research and death review committees. So a yes response to 1 or more questions should be considered a red flag for potential future harms and lethality. And it does require, moving forward to RIA 2 and 3 for more in-depth identification. The other thing is the assessment also asks about the frequency of the abusive behaviors if somebody does respond yes. And it's on a scale of 1 to 5, 1 being never experienced, 2, one-time experience, 3, once a month, 4, every week, and 5 daily. So again, really recommend this report. The screening tool is in the appendix of the report, so you can actually print it off and use it when you're with clients. But I think it would be helpful just to go through the 13 questions. So the first question is, has your partner followed or controlled your whereabouts to know precisely where you are? So that's things like stalking, showing up at your workplace or school, contacting you through a third party, contacting you with harassing phone calls, text messages, GPS tracking. The second question is, has your partner expressed controlling or jealous behavior towards you? So that's things like controlling your daily activities or finances, generally being jealous, your whereabouts. Number 3 is, has your partner isolated you from your family or friends? Number 4, has your partner ever hurt you? Number 5, has your partner assaulted you with a weapon? Explaining what a weapon is. Could be anything from a gun, a knife, to a baseball bat. Does your partner have access to weapons? Number 6 is, has your partner tried to choke, suffocate, or strangle you? Number 7, has your partner ever threatened and or tried to take your children away from you or move with the children out of the province without your knowledge or consent? This is something we see a lot in family law. Has your partner ever hurt or threatened to hurt your children? Has your partner ever threatened to hurt himself or herself? Number 10, has your partner disobeyed or violated any court orders in the past, restraining orders, bail conditions, peace bonds? Number 11, is there a recent or pending separation? If yes, have you noticed an escalation of your partner's abusive behaviors since separation? And number 12, has your partner threatened to kill you? Number 13, do you think your partner is capable of killing you or hurting your children? Again, if they respond yes to any of these questions, really important to move to RIA number 2, which you can go to the next slide. The RIA 2 is based on 7 categories of factors. So I'm just, for the purpose of time, just going to go through the first, which is like types of abuse, but the other 6 are, relationship history, going through that, the perpetrator's background, the survivor's background, the children's background, systemic considerations, and then there's a section specifically for Indigenous persons as well. And these questions in this stage of the risk assessment are helping to identify potentially harmful situations that can impact a survivor's safety. And some of the questions are repeated from RA 1, but the purpose is to sort of ask them again and see if more information is provided at that stage. So for this one, like I said, I'll just read from the questions that are asked for types of abuse. These are questions like, has your partner emotionally or psychologically abused you? It can be things like making condescending comments or calling you names, insulting you. Has your partner damaged your belongings or property? Has your partner isolated you from your family or friends? Has your partner expressed jealousy? Have they controlled your whereabouts? Have they cyberstalked you? Has your partner ever tried to monitor you or use tracking devices? Have they forcibly confined you or prevented you from leaving the house? Have they tried to choke, suffocate, or strangle you? Threatened any other family member or friends? Have they injured, threatened, or killed a family pet? Have they taken money from you? Have they tried to prevent you to work or look for a job, or even hurt you? Have they assaulted you with a weapon? Have they threatened to kill you, or have they placed pressure on you? These are the sorts of questions that we're asking at this stage. Like I said, there are other categories, but please have a look. This assessment tool is really good and really important. So then we'd be moving on to RIA 3, which is the next slide. And this is the stage where you're really wanting to develop strategies and actions that can enhance the safety for the survivor. And Emma's going to speak about safety planning, but at this stage, it really is essential for family court stakeholders to be discussing all the risk factors identified and discussing it in the context of with the survivor's input as well. And in some cases, this is the stage at which we might be wanting to consider involving other service providers like victim witness programs, child protection workers, shelter workers, and the court ultimately. One more thing I'll just say is that for each risk factor that is identified in one of the categories, a safety and action plan is required for each risk. So I'll pass it over to Emma to discuss safety planning, resources, and the legal processes.
Thank you, Kate. Okay, so Kate's gone through in detail what some of the tools are basically in order to identify violence or risks right off the bat. And she's right that it's important that we make sure to continue assessing the risks that continue throughout the matter, and they can change. But as I said before, a lot of times, at least in my experience, I have sometimes one consultation with somebody who listens, takes information, and then sometimes I never know what happens. Sometimes they may reconcile, they may end up coming back, but it's important that I can do what I can in that consultation to help them in that, to get some support at least. So discuss safety planning is something that is necessary, regardless of whether the person is intending to leave the relationship or not. And obviously those are different considerations. So safety planning can, things that I talk to clients about are, making sure that you have a way to leave the home if you need to. So keys, cars, wallet being near you. Is there somewhere you can go? Is there someone on standby who knows that you may need to go in a hurry? Safety planning for the children, having other, avoiding isolation as much as possible, and then providing referrals, which I will talk about in a minute. If they are leaving the home, if they're at a point where they are ready to leave the relationship, safety planning involves timing about when they leave, how they leave, when we are involved, when we tell their spouse that they have left or are leaving, when we go to court, if we go to court. These are all things that need to be considered. And that's going to happen probably not just in the first consultation. Really important is to consider a support network and make sure that as much as you can, if it's possible, clients have other people that they are going to also rely on. So one of the things that I always think really strategically about is who are the players that can be involved? How much support can we get for this one person? Because it takes a team of people to make sure that they're safe. So that involves a counselor if possible, family, friends, shelter workers, social workers, the Children's Aid Society, and police, if we feel like they're actually going to be helpful. And I can talk a little bit about that later. But I think the important part that I'm always thinking about is what is a network that's going to help this one individual, and how can I access any resources available for them or help them to access it so that together we can make sure that they're safe. Sometimes clients come with a sibling, a sister, or a friend who has finally basically urged them to at least just listen to the legal advice, right? Sometimes I'll have consultations. My sister just really wanted me to at least just hear what you have to say. And that's step one. And that step one can be a lot more feasible actually in a Zoom world, right? Because like Kate said, they can be in their car having this meeting, right? It's possible to do it. Whereas actually getting away and coming into an office would have felt a lot more daunting. And so if there is a sister or a friend, having that person there is extremely important. So if they ask me, do you mind if I bring my sister or my friend? 100%. Because now you have somebody that's listening to what we have to say from a different lens, and that's going to keep reminding this person about that. And that is going to work with you to try and keep them safe. So like, we know the data is that violence and murder can be at their highest, the risk is at the highest prevalence at the point of separation. Sometimes people don't appreciate that. So when there's a sister or friend, listen, I'm not in the business of scaring people, but I don't mince my words, because it's really important that the risk is identified so that the other referrals are made. Like Kate said, we have to be obviously mindful of fear. We don't want to be pressuring or pushing. So it's constantly, for me, a balancing act of wanting to make sure that the person feels it's a safe space, at the same time, not downplaying the risks so that it's taken seriously. So I talked about timing, and I'll talk more about timing when it comes to actually process. And then also, as Kate mentioned, intersectional considerations, other people that might be involved in the violence, that might be supporting the perpetrator of violence, and specific issues faced by certain communities. And like Kate said, check your own biases. So know when you need to spot issues that maybe are not something in my own community, for example. So understanding that I come from a certain lens, and that sometimes that bias can actually work in a different kind of way. So I'll just be perfectly honest. I think that sometimes there's a misconception that certain educated women are not going to find themselves in these situations. And my bias is not that I don't think that that's possible, but sometimes I have found myself, I'll be honest, I had a client who was a lawyer. And what was surprising to me, of course, I took it seriously just as I would with anyone else. But the amount that she was unable to have any understanding because of the coercive and control that was just eroding her ability to see clearly was in some ways shocking to me. And that was where I could see some bias of my own, thinking that this person who has similar education to me, same city, similar, white woman, so similar to me, that makes me kind of be surprised that it could be so, not surprised, but a reminder of how prevalent and how deep-seated the control can be to allow you to think that, in this case, she kept saying to me, I can't call the police because he's gonna tell them like that one time we had an argument, or like things that she was just so fearful of that were so clear to me what wasn't gonna be what was gonna happen. So that's just one example. Moving on to the next slide. So resources. So like I said to you before, what is the network? Like, how can we best help this person is by finding them all possible resources that can help them. So this is just a list of some examples of helplines and shelters and legal clinics that we will refer people to, or that we will contact if we feel like, we want to make some referrals ourselves. Okay, next slide. Actually, just before I get to this part. So the police and CAS. So I have absolutely seen situations where both of those organizations have taken reporting really seriously and have resulted in charges or strong statements by the Children's Aid Society, which have gone a long way to help my clients achieve court orders that help protect them and the children. But I can never know exactly what's going to happen. So it's trying to make sure that clients feel safe in reporting is something that I hope we continue to do better at. But I don't always have confidence that there's not bias or that it's taken seriously. Okay, so in terms of what do we do in terms of family law? So like I already talked about how there are certain proceedings or orders that we can seek that in which family violence plays a role. So exclusive possession. So do we think that what the information that we have is strong enough that we can persuade a court that right away the perpetrator needs to be out of the house? Exclusive possession is difficult because it's a high bar. We have affidavit evidence only usually, which means it's written. So you've got one person against the other. So, lying is absolutely possible. And it's not an order that non-legally married spouses can obtain. It's doable. We have done it before for legally married spouses, but it's even more difficult because it has to be as an incident of support. So part of a support claim, and it's even more difficult. So that's one thing we can do. So on an urgent basis, if someone comes in and we've identified that there is violence, that there is significant risk of violence, or that there has or will be. First of all, just going back, we absolutely have a duty to report to the Children's Aid Society. So if there has been violence that hasn't been reported, either towards a child or in front of a child, we have to report that. And the client needs to know that we are going to report it unless we have confidence that they have. And it can be anonymous if they don't want it to be known, but we actually do have a duty, and that's certain. And like I said, in some cases, those reports have been taken really seriously. What do we do when we've identified violence and the person is ready to leave the relationship? Because we can't force them, obviously. So when we've identified violence and they want to leave, that's when there's a family law matter. And there are various processes that we can take. When we think court is necessary, it's typically because we think exclusive possession is required. It's because there's no accountability or understanding on the part of the other person as to the fact that there is violence and that they need to be separated, that there are children involved. So it may be that we want to bring an urgent court proceeding to seek, temporary orders for what we used to call custody, decision-making responsibility, parenting time, potentially a restraining order, supervised visiting for the other person, and or exclusive possession. But that being said, we don't always, and at least we are constantly taking a very strategic and careful approach to how to move forward. We don't always jump right to an urgent motion if we think that there's a safe way to negotiate. And that is, like Kate said, that's something that we constantly have to determine. But there's definitely an apprehension to run to court. First of all, it's extremely expensive. It's stressful. There's no guarantee about the results. We've already highlighted some of the problems that we see in the courts. And something that can actually happen in court is an ongoing demonstration of coercive and controlling behavior and manipulation on the part of the abuser. So they will do things like litigate you out of all your money, lie, gaslight in court proceedings, bring unnecessary motions so that the matter keeps going before court, create litigation fatigue. So there's a lot of reasons why we want to keep matters out of court if we can. There are some ways that we can do that if we feel like it's safe. So it's constantly weighing the safety versus the other option. So if you wanted to just go to the next slide, I'm just going to kind of wrap up so that there's room for questions. So I have spoken, I think I did a podcast with Flu, and I have spoken with, in our mediation training course, and with Christine Kim, who taught both of us, who's a social worker and has a lot of experience in mediating cases involving intimate partner violence. And it is an age-old debate about whether or not mediation is a safe space. A lot of people have historically had concerns about, just continuing the power imbalance and therefore an inability to reach a fair resolution if one party holds all of the power. And that is definitely something that we need to always be mindful of. But there are some reasons why having a mediation approach can be helpful in some cases. So first of all, you want to make sure that you're working with a mediator who is accredited, trained, understands spotting intimate partner violence, and knows how to potentially work to achieve resolution in those situations. You can do mediation in different places. So we can do it on Zoom, for example. So if there's actually a physical separation of the parties, it can be really helpful because it means that we can all be virtual. You do never have to be in the same room, either physically or Zoom room. It can be a way to try and resolve matters, but it really is obviously fact specific. It depends on the issues, and it depends on whether or not the abuser is willing to engage, basically. So that's kind of the long and the short of it. I think we could both talk about it for a while, but we did want to leave some time for questions or comments, of course.
Thank you, everyone, for being here today. I know you took time out of your busy day, and thank you again so much, Emma and Kate. It has been wonderful having you, and take care, everyone, and have a good afternoon.